How do you evict a tenant? Maybe they're not paying rent. Maybe you just want to get your house back. How do you actually get rid of them? What is the right notice to serve? My name's Samuel Leeds, and I've been a full-time landlord for over 15 years, and I've had hundreds of tenants myself, and I have had to serve evictions on some of them. So in this video, I'm going to be talking about the different types of eviction notices that you can serve and how it works, and what to do if you serve notice and the tenant still doesn't pay rent. How do you actually get them out the house legally? So you're going to enjoy this one. First thing is getting your right foundations at the beginning. If you've got a tenant in a property and you're trying to evict them, if you didn't get them in the property the right way in the first place, it's going to be a logistical nightmare to get them out. So what do you need to do? Number one, make sure that you have a copy of the contract that they are in. The amount of people who I've spoken to that have said they've got a tenant that's not paying rent, and I'm like, okay, what do you want to do? I want to get rid of them. Okay, what does the contract say? I can't find it. So don't lose the contract. You'll be screwed. Also, if you've taken a deposit from the tenant when they moved in, make sure that you have registered that deposit with mydeposits.co.uk, because if you don't register the tenant's deposit, not only can they sue you for 3 times the amount of the deposit, but also it could potentially make it very difficult if you're trying to evict them if you haven't got their deposit registered. You also need to have given them some information when they've moved in. Now, it might be that your tenant is managed by a management company or a letting agency. So when the tenant moves in, they need to be given 3 things in their hand, okay? Or sent over via email, but you need to be able to prove that you gave this to the tenant when they moved into the property. And those things are, number one, a gas safety certificate. A gas safety certificate is a certificate to show that the gas is safe. And it's something that you have periodically as a landlord. And when the tenant moves in, you need to get that in their hands through email physically and be able to keep evidence that you gave it to them. Also, the government's how to rent guide. This is just making sure that they understand how to be a tenant and how to rent. It's a guide that is mandatory, that is put in the hands of all tenants, and it is the landlord's responsibility or the letting agent's responsibility to put this in their hands. And thirdly, the EPC certificate. That is the energy performance certificate of the house. Every house that is rented out in England needs to have an energy performance certificate, and the rating needs to be a maximum right now of E, but the lower the better, and that needs to go in the tenant's hands or in their email inbox when they first move into the property. Now, if you don't get the foundations right at the beginning and you miss this stuff, and then things go bad, and then later you want to evict the tenant out of the property, if you didn't put this in their hand, it's going to be very, very difficult to do it. I've had situations where I've had letting agencies that have given the tenants this information, but then the letting agency has either gone bust, or the letting agency has been taken over and bought by a bigger letting agency, and then the tenant has stopped paying rent, and then I've approached the letting agency and asked for the information, and they haven't got it on record because they've either rebranded, they've been bust, they've been bought out, and this has been an absolute nightmare for me as well. If you've got a property and it's managed by a management company, make sure that you're managing the property management company to ensure that these things are put in the tenant's hands, and you have proof and evidence that the tenants has this in their hands, lest it bite you in the bum when you come to want to evict them at a later date. There's 2 main types of evictions for regular tenants. When I say regular tenants, that's because some tenants might be commercial tenants, or they might be guests, or they might be on different types of agreements like excluded license agreements, full repairing and insured lease. This is not what I'm talking about. I'm talking now for the regular, normal tenant on an assured tenancy agreement, or a family in England as well, specifically, because this is going to be the average person watching my YouTube channel, and this is most of my portfolio, which is residential property in England. Now, there's 2 types of ways to evict a tenant. Number one is Section 21, and the second one is Section 8. Now, a Section 21 is a no-fault eviction. This is just when you want your property back. Now, if you've got a tenant and they're in the property and they're on a 12-month agreement, at the end of the 12-month agreement, if you want your property back, all you need to do is serve a Section 21 notice on the tenant. If you serve it properly, and if you gave them their how to rent guide and the EPC certificate and the gas safety certificate when they moved in, this is actually very, very, very straightforward. All you need to give them is 2 months notice to move out. If they don't move out after the 2 months notice, you don't even need to go to court. All you need to do is you need to send the court the documents to show that you've served the notice, to show that you did give them their gas safety certificate, EPC, how to rent guide when they moved in. When you send this to the court will look at it, they'll review it, and they will rubber stamp it, and then you will then be able to physically get a bailiff, a certified bailiff, and get them out of the property. Where things get more problematic is if you've got a difficult tenant that's not paying rent. Now, if you've got a tenant that is being antisocial, not paying rent, and you want to get rid of them, you can serve a Section 8 on them. There are many different grounds for a Section 8, and I'm going to go through them now. The most common ground is that they're in serious rent arrears. Serious means 2 months or more. So if the tenant has not paid rent and they are 2 months behind, you can serve them with a Section 8. When you serve them with a Section 8, you can give them a minimum notice period of 2 weeks and they have to go. If they don't go after the 2-week notice period, that's when you can start court proceedings. But there are 16 other grounds that you can serve a Section 8 notice. And one of the other grounds is that you just want to live in the property again. You can't use this notice if you bought the house during the tenancy, if you bought it while they were in it as a sitting tenant. Also, if you're selling the property. If you want to turn the property into a holiday let, as long as the tenancy is a fixed term of less than 8 months, and at the start of the tenancy you did tell the tenant in writing that you might want the property back for a holiday let at some point, and during the 12 months before the tenancy started the property was occupied as a holiday let, then you can tell the tenant, Section 8, bang, that you want it back and you want to redo it as a holiday let, and you can serve them 2 weeks and they have to leave. In the same way, if your property was previously used as a student let and now you're moving a tenant in, as long as you tell them in writing that you may at some point want to turn this back into a student let and the tenancy is a fixed term of less than 12 months, then you can also serve a Section 8 and get the tenant out within 2 weeks. You can serve a Section 8 if you want to turn the house into a religious residence, 2 months notice. If you want to demolish or redevelop the property, if the tenant dies, if the tenant is committing crime or antisocial behavior, minimum term, you can get them out within 1 month. If there is an immigration status issue with the tenant, if the tenant makes any false statements, you can get them out within 2 weeks potentially. If they ruin the furniture, riot or domestic abuse, noise, crime, if the tenant trashes the property, the condition of the dwelling house or any of the common parts has deteriorated owing to the acts or neglect by the tenant or any other person residing in the dwelling house, minimum notice on a Section 8 is 2 weeks. So there's many reasons how you can get your property back as a landlord. If it's not their fault and you just want them to go, it's 2 months on a Section 21. Don't have to go to court. You have to send the information to the court, they'll rubber stamp it and get them out. If the tenant is being abusive, if they're not paying rent, they're being disruptive, or any of the many reasons that I talked about, you can get them out in a Section 8. However, with a Section 8, it is more complicated because now it has to go to court and there is more grey areas and discretion by the judge. So, for example, if the tenant has a lot of debt, there is something called breathing space debt respite scheme. A breathing space prevents creditors, including you, the landlord, from taking action against debtors. Is that fair? Well, it really depends, because if a tenant is a single mom and has lost their job and now they're in debt and they're struggling, is it fair that a landlord will be able to just come in quickly and give them 2 weeks and then they're out on the streets? So having a 60-day rest to sort out your debts, this is something that the judges, when you go to court, they will look at, and tenants ultimately do have rights. Most tenants do not want to go to court and lose in court because they will end up then having a county court judgment against them and it'd be incredibly difficult for them to rent a property again. But if you do go to court and you win in court because you did it properly and you followed the right protocols, then if the tenant still doesn't leave, you can ask the court for a warrant for possession. Once you have a warrant of possession, then you can get a certified bailiff to go around and evict the tenant if they haven't left by the date. The law is there for a reason, both to protect the landlord, but also to protect the tenant. And in my opinion, the laws are reasonably balanced in England right now. If you just change the locks because the tenant doesn't pay their rent, that is a crime. If you do things like take out the windows or harass the tenant or threaten them or go around with a baseball bat, again, that is a criminal offence. As a landlord, don't do it. If you don't want to deal with tenants that have rights, any rights at all, then you should consider investing in commercial property instead, where the tenants do have no rights. And if they don't pay rent, you have 7 days to evict them and you don't need to go to court. Or you could consider instead renting your property out as a company let to a company, or renting it out on short stay lets to guests. There are many alternatives if you don't want tenants to still make money in property, but I hope this has given you a helpful oversight of how the eviction process works. I would also recommend always having a solicitor or an eviction specialist on side, on team, to help you do it properly, because this is a little bit of a minefield if you haven't done it before. I hope you enjoyed the video. If you did, hit the like button, subscribe, and I'll see you guys next time. Thanks.